Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 226 of the NCDWI Guy podcast. On today's episode, I have Justin Olsinski, criminal defense lawyer in Charlotte, on the podcast, talking to us about the rule out theory. This is a really important episode if you do trial work, particularly jury trial work. David Ball has kind of championed this rule out method, and both Justin and I have attended one of David's CLEs where he's conveyed this. You can go get a copy of David's book. It's Rule Out for Criminal Defense Lawyers. It's available on Amazon, and it's an incredible strategic way of thinking about how to present a criminal case in trial, particularly in a jury setting. Unbelievable stuff. If you ever get a chance to attend one of David's CLEs, definitely do that. Buy his book. I was looking for my copy of the book before I began the podcast today, and I think I must have given it away because I can't find it. And Justin said the same thing on his end, that he gave his copy of the book to somebody else. So we're spreading the gospel, so to speak, of the rule out theory. But anyways, Justin is totally in on criminal defense. You're going to hear the passion from him about what he does, that this is why he went to law school. He's one of the few lawyers that I've ever talked to on the podcast that went to law school with the intention of becoming a criminal defense lawyer. So you can hear the passion about what he does coming out through the conversation today. Justin and I both became members of the bar 2009, started our own practices in 2010, and both focus in criminal defense, and that is where the paths diverge. Justin is very much focused on high level felony cases. Again, 100% in on how to present and handle criminal cases and pushing those cases to trial when that is the right play to make. So really enjoyed this conversation with Justin about the rule out theory, and get ready to rumble. Well, Justin, I'm looking forward to the conversation today. Reptile theory, reptiles and lawyers coming together. This is what it's all about. So very excited to have you on the show, sharing your wisdom with the audience about how to kind of present some of these techniques in a maybe jury trial in particular, but certainly in the district court side of things, a lot of these same things can apply. But really, really excited to have you on.
Yeah, well, it's great to be here, and I'm glad to talk to you and share whatever wisdom I do have.
Yeah, I'm excited about it, Jess. Well, tell maybe a little bit about kind of what led down the path to you going into law school, and then kind of ultimately why you decided to focus specifically on criminal defense.
Actually, I'm one of the few people who went to law school for the sole purpose of being a criminal defense attorney. So that was all I promised, that when I went to law school, that's what I wanted to do.
What inspired that? Like, what was the reason for that?
I don't know. I guess part of it, I grew up watching Matlock with my mom.
That's awesome.
And say that didn't have anything to do with it, because
you wanted to wear a seersucker suit.
Yeah, I wanted to have a hot dog for lunch and then go in there and make someone else confess to the crime. No, I think that always intrigued me. And, I noticed I had a skill set for sales through some sales jobs early in my life, but that aspect really didn't allure. I felt like that wouldn't be something where I get to utilize my brain as much. So,
yes,
I think those two things kind of combined. I always wanted to, find that way to, I guess, watching the shows and the defense attorney is a focal point and all that stuff always interested me and sort of spun me in that direction.
Yeah, I mean, I feel like, and obviously there's that like famous thing in the jury instructions, especially from the prosecution, that if you've watched crime TV, that's not what this is going to be. This might be very boring or whatnot. But I will say, like, if you watch any kind of like trial, like attorney movies, law shows, the ones that are about like crime are just way better than the ones that are about like, somebody suing somebody else. As much as you can dramatize that or like, champion the person that is going to bat for somebody that has been seriously injured, which is, again, I'm not taking anything away from that, but like
Yeah.
the crime movies are like, that's where it's at. So
Yeah, I mean, I think that's part of when I wanted to do this was to get into handling, very serious. I mean, that's what I'm doing now,
yeah.
just very serious felony stuff where people's lives are on the line. I kind of always gravitated towards that aspect of things, having that kind of importance on it, life changing, more of I like the higher stakes, so to speak. So
Yeah.
that kind of gravitated me towards that. And then finally getting up there in terms of just working through the process in district court, getting the experience.
Yeah, I mean, you definitely are one of the few people that have been on the podcast that, when I asked that, like, what led you to law school, like, knew going in, like, criminal defense was where it was at. Did that kind of like change the direction of like how you approached law school classes, like what you were doing during internships? Because for me, like I really didn't find that until like my third year of law school when I did moot court and really got excited about a criminal problem that we were kind of doing as part of the moot court competition. It was kind of then I went in like thinking I was going into real estate law, and
Mm-hmm.
that market crashed and like it was everybody was going into real estate law, and then it was like, all right, well, I guess we're all going to find something else to do. But yeah, there was no intention going in on my end. So what did that look like from a law school perspective?
Yeah, I mean, the first externship I was lucky enough to have with a very prominent defense attorney out on Long Island, and that only kind of pushed me further
Oh,
towards
that's
that.
cool.
Just driving around with him, going from federal state court in Manhattan, Islip, and all over New York. Although it did lure me because I went to law school wanting to be a big shot Manhattan defense attorney, but living out there kind of turned me to like, I don't really want to live in this world here. So it did turn me away from that, but just you know the experience of getting to help people, and I had an internship with legal aid in Nassau County, which was criminal there. I think it's civil here when you talk about legal aid. So just helping people and seeing all the stuff that they go into. I mean, but I did get a chance to, because of that, take more focused classes on that area. Anything that was like trial related, extra trial advocacy. I think we had a prosecutor's role or something type class where you prosecuted a case. So you got to do, try to do anything that was in the criminal realm of arguing cases and presenting. And, it really helped out knowing that focus that I wanted to do that, because we had a special, like, not in law school, but like during a winter break, like a 10 days NIDA or whatever, National Institute of Trial Advocacy or something, did a special class, and you pay a few extra thousand to do it. And that I thought was the most I learned.
That's so cool.
Because that we had actors come in and do the cross examinations and the directs and all that stuff, and you're getting critiqued by actors just on your presentation, and you kind of learn, like, oh, you're in law school and you're thinking law, but
Yeah.
trial is presentation, and presentation is acting and being in the right spots and making sure you're talking to the jury, not over them, and so forth. So it really kind of sparked, a new interest in it, so to speak, in terms of like that aspect of the presentation.
Yeah, that is super cool. That is, I mean, that's like kind of next level trial prep at the law school side of things. So that's really nifty. I think that's actually kind of like a good transition in terms of kind of, what we're talking about today, because I do think that we, as kind of lawyers studying and eating and breathing the law, we get so caught up in terms of the law, and then like obviously kind of all of the investigation and facts of the case, and trying to kind of like work through where is our defense, how are we going to attack this, or are there legal attacks. And so much especially of the jury end of things is the presentation, is kind of how you are telling the story of your case. So you had kind of brought up the thought process of, hey, why don't we kind of talk a little bit about kind of and I don't know even if you use the word reptile theory. That's kind of like how I kind of
Mhm.
think about it. But kind of this theory from David Ball, and we both, I guess, been to one of his CLEs, and you may have done more because I just did the one CLE where he kind of talks about applying the reptile theory to criminal defense. So tell me kind of like what that theory is, or kind of how you think about using kind of that reptilian brain theory in the criminal setting.
Yeah, and I think he used the rule out method is what he refers to as criminal, but it started as reptile in the civil world, um, and basically just you're trying to underscore people's natural subconscious and how they view the law, or how they view criminal defendants in particular in this situation, because part of that natural human order that we've had since the beginning of humankind is that I'm going to protect myself above
Mm.
all else, and I'm going to protect my family above all else. So you're trying to, which means I'm going to find your client guilty if there's any question, because that protects me. If your client's behind bars, I'm protected, and my family's protected if he's committed or she's committed any crime. So the whole theory behind it is you're trying to get past that, and the only way to really get past that is to elaborate that the greater harm to themselves and their family and to society is if they don't follow the law, and the law is proof beyond a reasonable doubt, and that's how you kind of you snowball into that rule out method in terms of the government's job to rule out every reasonable doubt. So if there's any reasonable doubts involved, the law is pretty clear. I find that method, it first of all makes my job easier. I
Mm.
don't know why attorneys don't do it, because every case I'm arguing in jury trial is the same in essence how I'm presenting. I'm telling a story, and I'll throw some things in there. I know, like, we grew up when I went to law school, and I'm sure you did too, and you're learning trial strategies, and everything was like, who tells the best story is the winner.
Right.
That type of mentality. But from doing this long enough, I think I went to David Ball's CLE maybe 8 to 10 years ago, and I've
Probably
incorporated it.
about the same. Yeah.
So, and I've been focused and just trying to fine tune things with that presentation. And when I talk to the jurors, I've had jurors come back and tell me, like, listen, there's no way the government can prove your client's intent beyond a reasonable doubt. Like, I mean, that's great for me, because I obviously did something right in that presentation, that they understood, I mean, how high that burden is. And I think it kind of disarms the jury when you do that strategy from the voir dire from the start. You're talking about reasonable doubt. The whole case is about reasonable doubt. It's not about whether you like my client, whether you like me, although you are trying to steer them clear of what their initial interpretation of whether it's a DWI or trafficking or murder, what their impression of that person is. You're trying to throw them off that vision they have in their head. But by putting that reasonable doubt as the focus, I think it makes their job easier, and it gets them discussing things. Even when I lose, it's very rare that they're not out there for an hour and a half, 2 hours discussing it, even if, it's a case that really shouldn't have taken that long. So I think that does create some sort of discussion inherently about reasonable doubt and that level of proof. And the district attorneys, then it makes the job easier too, because they kind of play into it. Like, this is my burden, and this is only hold me to my burden. And then you just
Right.
you, like, yes, exactly. Hold them to that burden. Don't let them lower it. And then you let the jury know, looks like they're trying to lower it right here, aren't they? When they say this or they say that. So it just makes it easier, I think, to present it, and it's more persuasive. And the juries tend to acknowledge that. And
Yeah, how do you bring that into the voir dire conversation now that you've kind of been using that for a while? Like, but how do you kind of introduce the rule out theory, and then how do you get jurors talking about that?
Well, I'll talk about just, whether they've heard reasonable doubt, what they've heard, kind of ease into it with definitions, stuff like that. And different judges will have, I'm always prepared to get objected to at voir dire and so forth. The main one that gets eyes raised is the Tylenol example. I'm not sure you've heard this or you've used it.
Definitely have gotten some objections from using that.
The Tylenol, and I'll bring the Tylenol bottle with me. And I'll bring it out.
The bottle is essential. I'll tell you, if you're doing this thing, you've got to have the bottle for sure. So,
and you start explaining, and the observer's like, because then I'll get objected to, like, where were you going with that? And I'll go, well, here, and even if you get objected to it when you start it, you can kind of tie it back in with just, I'll ask a question, juror number 6, when's the last time you made a decision beyond a reasonable doubt? And, trying to get them dialogue, get them talking, and see where because sometimes people say ridiculous things that they use beyond a reasonable doubt. It's like, I'm pretty sure you didn't make your lunch choice beyond a reasonable doubt. There's always some question about what you want, but you get them talking, and then at least you get an idea of where their head's at.
Yeah,
and get them thinking differently. That I'll bring up. This obviously this isn't this isn't a level playing field, and do they think they can hold the government accountable, or they think my job's too easy? Because that's one of the questions I like to ask is, do you think my job's too easy?
Yeah.
And because it puzzles them, because, again,
they see you as the one with the burden to some extent.
Yeah.
Right? Like, I mean, it's
they want to hear my clients. They want to hear the evidence. Yeah. And even if I'm not, even if I'm planning on putting on evidence, I'll still present the same way as if I'm not.
Yes.
Just so they understand, I don't have to put on anything. Yeah. I can just sit here, say nothing, just keep hitting that avenue so that they're prepared for that. And it's very effective. I've found it, just talking to juries in close cases, or sometimes even cases I don't think I have that strong of an argument. Things will work that way.
Yeah, and just for anybody that kind of doesn't know what the Tylenol example is, do you mind to like kind of share that? I've done it more in kind of like the closing side of things so much than in voir dire. So kind of how do you introduce that in the voir dire side of things?
I'll just, if some of you have been around in the 1980s, you may recall that there was a Tylenol scare. There was a situation where someone was going around lacing bottles of Tylenol with cyanide. Now, put yourself in that position. You're in the 1980s. You just bought a bottle of Tylenol, and you just hear about that this bottle, there's a recall because that bottle may have been laced with cyanide. Now, would you put that bottle with 20 capsules on your medicine shelf for your family to use? And they're going to say, absolutely not. And then why wouldn't you? And then depending on their answer, you can kind of phrase it too with them as like, because you have reasonable doubts about the safety of that next capsule, don't you? And would that change if it was 1 million or 100 capsules? No. 1 million capsules? No, it doesn't change because reasonable doubt doesn't change. It's not a numerical figure. It is an existence of whether you have it or you don't. So you kind of explain it that way. And depending on the judge, depends on how much detail you can go into it.
Yeah.
But, usually the state will say some stupid hypothetical about this. What is it? Direct evidence and circumstantial evidence. So,
Yes.
and
Yeah.
like, Your Honor, they're talking about what evidence is. Why can't I talk about what reasonable doubt is?
Yes.
Ultimately,
I mean, and they, we were talking about that a couple of days back before the call, and I was actually, I wasn't really kind of thinking about it in the context that they do use that in voir dire. I was kind of thinking like further, somehow I was thinking that was something that they argue in closing. But yeah, I mean, I guess that's a great way to phrase that because they're talking about that in voir dire as well. So that's powerful. I think that's such a cool thing. I mean, to me, the only real objection is almost as to the like historical nature of it. I had a case that was around Halloween and basically kind of did the same type of example with Halloween candy. Like if there was, somebody in the neighborhood that was known to have like basically poisoned some of the candy and you don't know which exact, candy it is. Like, I mean, you got this bucket full of candy and, was it your kid that went to that house? Did they go to that house? Doesn't matter. Like, I mean, you're not going to let your kid eat that candy. So, I think that there's other ways too, if there's like an objection from, because I've had a couple of times where they've objected based on it being, effectively like a representation of a historical event, which I don't even know why that was like it was like, there's not going to be any evidence, judge, about the 1980s. And it's like, yeah, there's not going to be any evidence. Like, I'm not trying to, this is all for explanation purposes here. But yeah, I mean, that's just, it's interesting, what the attack points have been.
Yeah, and I think I've had DAs object that it was a stakeout question, which like I don't understand. I go up to the judge's bench like I don't think the district attorney knows what a stakeout question is, but it's really just explaining the law. But I also understand I'm not going to win by fighting with the judge about this. So depending on how they rule, how quickly, and how much the district attorney gets into, because sometimes they'll do the circumstantial direct evidence, snow, rain type of situation, but then sometimes they'll also do another, hypothetical, which at that point it's like, you're allowing them to do hypotheticals to explain the law. Why can't I do a hypothetical to explain the law? That would, and then the judge kind of in it at that point.
Yeah, in terms of, once you're kind of like, oh, go ahead, Justin. I'm sorry.
No, I was just filling dead air.
Yeah, no, I think once you've kind of like walked through that presentation with the jury in voir dire, how does kind of using that theory look, kind of in opening as you're kind of like going through questioning? What does that look like before closing?
Opening is usually what I'm trying to do is get them to forget about what the case is actually, what we're here for. Whether it's this isn't a case about rape, or this isn't a case about murder, this isn't a case about DWI. This is a case about the fundamental principle of our justice system. And every case is about that fundamental principle. And are we going to hold the government accountable to their burden? And then, kind of go in a little bit of that and then lay out some of the things I think are reasonable doubts that they need to pay attention to, and follow the law. I'm always going to be the person championing the law, because then it kind of, I think it flips them the opposite way of what they think a defense attorney is going to be, is kind of slimy, and skeezy. But if I'm just saying, just follow the law, do your job, that's all I'm asking you to do, then it disarms that notion.
Yeah,
And,
I remember David kind of talking about how jurors, I can't remember what he called this, but basically almost like a kind of anticipated type. I can't remember like
yeah, yeah, like something where, it's instinctual what people, their subconscious tells you about a different, whenever they hear something,
yeah,
which I think was around the time when I took it, was when Donald Trump was saying, rapists and murderers with immigrants. And David Ball was like, yeah, I mean, if you go to the subconscious of people, that's what they feel at their deepest core. And that's a trigger. And so if you have a client like that, then you have to kind of show that, oh, he's a legal citizen here.
right.
You got like
Yes.
someone of that, or if they're thinking thug, or you're always trying to send him off. He's educated, he goes to school, all these different things. And defense attorneys, I think, was, slimy, shady.
Yeah. It was basically like
So
a liar and not going to be trustworthy. So yeah, I think that's a really great way of really trying to kind of, basically, uh, kind of be outside of that like anticipated actor that the jury is kind of thinking, this person's going to try to trick us into, finding his client not guilty. And when you kind of just immediately are like, again, do you think I have it too easy? Like the whole kind of flipping the script of like, this isn't a case about, you know, rape, murder. I think that is such a powerful way to kind of like almost get away from the story framework. And it's not to say that you don't necessarily have a story to tell during the case. Like obviously you kind of
mhm.
want to tell your client's story, but I think that this whole narrative, normally like the DA is really trying to tell a narrative, because they know exactly what evidence is going to get presented, or at least they should know what evidence is getting presented. They know how they're going to put that, like what order. Like it's very much this narrative framework. And when you're just like, here is how you're supposed to view whatever the state tells you, that's the main thing, like to keep focus on. Like here's how you've got to view every single thing that is being presented to you by the state. That really kind of de-emphasizes that like overarching narrative that the state's trying to kind of work through.
Yeah, and I think too, it makes it easier in this versus the story. I mean, if I have a good story, I'm certainly going to try and spin that. If I can easily blame someone else and put someone else towards the culpability, I'm going to do that. But most of the time, I don't have as good of a story as the district attorney. So, arguing stories isn't a winning philosophy, I don't think, many times, because my clients don't have a consistent story that is going to line up with the evidence that's going to be presented. And you end up, I think, just trying to explain away all the inconsistencies of your own narrative, versus just saying this person's not consistent with their statements. And if they're not consistent, that's the whole, it's their accusation that my client did this. If they're not truthful about this, you can't trust anything they say beyond a reasonable doubt. And it makes it a little easier to, now in sex offense cases, it always depends the age of the person. It doesn't really matter if they're of a certain age, they're going to be believed. But sometimes you can get that in other cases where there's going to be a clear motive or anything like that. It makes them really start to question it and limit how much you have to put on as well. But yeah, I also tend to put on my clients in some of those cases too, in terms of, I haven't had never had necessarily a jury say, wow, I really liked your client, he did great, I really believed him. But I don't think I've ever had a case where my clients testified where the jury convicted him because he testified.
Right.
It's like, especially if you're dealing with, I deal with a lot of sex offense cases. If you hear X and X is accused of this heinous crime, it's easy to demonize someone when you don't have a voice.
Yep.
Once they hear you talk, once you become human to them, I think it's harder for them to, it's the same way when you hear any generalization in society, it's easier to just lock up whatever people don't agree with you until you actually sit face to face with those people and realize they're really not that much different than you. They're got a family, they care about their kids, and it's all they want. So, having them talk is, I think, important in a lot of circumstances.
Yeah. I mean, I think, the humanity aspect of things, I mean, you just got such a short window to kind of communicate who your client is. I mean, obviously to even communicate who you are and, kind of how you're presenting the case, tone, the way that you're moving, all those things are like, real key indicators to the jury. But it's really difficult to kind of like have the jury get any sense of who your client is. Like you can be passing notes back and forth and, give your client a cup of water, touch them on the shoulder or something at a specific moment. But it's really hard to like get the jury to, view your client as a human being until they're on the stand. I've not had too many. I've had a couple of times where my client has testified, but most of the work that I've done is DWIs, and there's just not
there's not much.
There's not much of a story to tell, or you can almost tell the story through the officer video, because there is conversations that are happening on the video that may come into evidence, show your client talking, being like polite and nice to the officer. So there's other ways to kind of get some of that across without them being on the stand in that sense. But I can see why, the human element is so critical.
Yeah, especially if you are doing, if the punishment's severe,
right?
Because at the end of the close, usually I'm telling them, this is what my client's looking at. This is his life, literally. It's in your hands. So, accompanying that with the humanity aspect, I mean, do you want to? I think it just makes them at least focus on that reasonable doubt even more so than they normally would. And I think every criminal attorney will say, and I had a DWI trial, jury trial once, where one of the jurors came up to me after we had lost, and I thought I should have won it. And she was like, well, I didn't think your client was going to get much of a punishment because he seemed like a good kid. Like, that's good to know, but it doesn't really help me in this situation.
Yeah.
But I mean, there is something where there's lesser punishment. They're not worried about it because like, it's going to be a slap on the wrist anyway, or it's not going to be something. But when you're like, this is 50 years, 25 years, it allows them to be, or pushes them a little bit more to use that reasonable doubt. I think reasonable doubt kind of changes with the severity of the case.
Yeah, 100% agree with that. Yeah, I guess in terms of the jury selection, just kind of one more question on that front. With jurors, in terms of like providing answers back and forth about kind of your rule out framework, are there any kind of like character traits that you have kind of tried to look at as an indicator that this would probably be a good member on the jury for kind of following the rule out theory, or it doesn't seem like I'm able to kind of connect with this juror based on these particular answers? Have you found like any kind of overarching themes or career types that are kind of particularly helpful in terms of presenting that rule out theory?
It depends on the case. I think sometimes there's issues with any type of sex offense case in terms of men. Men tend to be the worst because they're not, as generally speaking, as open-minded about that type of thing. They hear an allegation. Plus, they're going to need a female to tell them this is okay, like in any of those cases. So I think any kind of advanced, engineering degree, I like people who generally have been through like a divorce, to be honest. I mean, they've seen things. They know that people aren't always telling the truth, because I think a lot of divorces are pretty nasty. So, they're more likely to see like, okay, I understand that not everything someone says or the accusations they make is going to be 100%.
That's interesting. Yeah.
But characteristics of a person, I mean, I think educated helps, but you kind of see what their answers are.
Yeah.
I mean, you can weed out a lot. I mean, you'll be surprised about, I mean, you're probably not. You do enough jury trials, some people are going to say some insanely, maybe offensive or just I can't follow all these laws. Talking about right now, I was like, all right, well, it's like, no, they're all rapists. Okay, I mean, you get some of those answers like, well, at least we got this out. We got this out in the open. But you ask those questions, and then if you get a bad answer, you get a questionable answer, you can then just go down the list of the jurors. What do you feel about that? It gets people discussing it, and it helps too. If you get someone saying something completely outlandish, lock them all up. I think he's guilty right now. Then it helps the other jurors go, I don't want to be like that guy. I don't want to be that nut job who's not even willing to listen. He thinks they're all guilty or the government's in on everything. I think last trial, someone was talking about some kind of conspiracy, the government doing. Just like everyone just sort of looks and laughs at each other. But,
this ain't going to be a good fit for anybody. Yeah. I think one of the other, I think this is from the voir dire questions in David's book. So I think his book is available on Amazon, The Rule Out Method of Criminal Defense. It's an ABA publication, David Ball. But I think one of the other examples he used was like basically using a quote from Benjamin Franklin. Is it better that 100 guilty people go to jail versus one innocent person go free, or like where do you fall on that? Like if there's 100 people convicted, would it be better that they all get convicted despite one innocent person getting convicted, or 100 people go free even though 99 are guilty? And I definitely think you get some interesting answers on that as well, because I think that's another one of those kind of how important is your job kind of questions. It's like, as long as we mostly get it right, then that's where the standard is. Or is it like, no, like the whole purpose of the rule out standard is to make sure that one innocent person never gets locked up. Like that's why this is kind of created this specific way. So I feel like that's been a good question to provoke a lot of interesting answers. People like really get thrown. They stop and think about it. It's not like I think one of the that's I think pretty high in the list of questions that I have as like kind of standardized questions for jury selection. And one of the reasons for that is that they've just gone through this like laundry list of yes answers in response to the state's, voir dire. It's like, are you going to follow the law? Are you going to, do what I tell you to do? It's very just like nod your head. There's not a lot of back and forth. And so try to just like push that out there as like, hey, let's just talk about stuff a little bit.
So. Yeah. I mean, any provocative question that gets them talking about the law or just how they think is beneficial to that type of to the rule out method in general. I always harp on the I kind of drape myself in the flag kind of, and especially in closing with regards to that in terms of the Constitution, and the reason why we have it set up to this standard is because we've all agreed as a society that it's better to have a guilty man go free than an innocent man go to jail, because freedom is the most important thing that we all value in this country. We're Republican or Democrat, it doesn't matter. Freedom is what separates us, what we believe is our greatest principle. So I think that also kind of, all wraps it up nicely for the jury in terms of understanding why it's so important to follow that standard.
Yeah, I love that. That's awesome. Yeah, I guess in terms of closing, beyond that piece of things, is there anything else specifically that you kind of regularly put out there on the rule out theory in closing? Obviously, case by case is going to be case by case specific, but anything that is kind of a generalization on that front?
I mean, if I have something really clear that I think, part of the rule out theory makes it easier, especially if they're missing an element or something like that, where it's clear. Most of my cases aren't that clear in that regard. So I don't necessarily, I know David came up with some video in terms of using boxes.
The domino theory. We've got the boxes downstairs.
Yeah. Well, I haven't pulled that out. I haven't done the boxes, but part of actually from way back in law school, I was telling you about the training earlier, is just trying to keep the jury's attention. And part of that is, just elevating and lowering my voice, changing the tone so that they know when something important is being said, and always using a visual like a PowerPoint so that they can, see all that stuff. I do always use a pyramid thing with reasonable doubt on top, just so they understand, like,
yes. Yeah.
You can take away someone's kid with a lower standard. I mean, that seems pretty significant to me anyway. And then luckily in North Carolina, we're allowed to say the punishment aspect of things. So my brother's a prosecutor in Indiana. And I'm like, yeah, I tell him they got 25 years. It's like, how can you say that? How's that? I was like, it is in North Carolina. That's all I know. But he was a prosecutor there. He's like, no defense attorney they don't even have jury trials because the juries are always going to convict. So they just do bench trials because there's no attorney even takes it. So it's just interesting to learn all the different states.
Oh, it definitely is. Yeah. Yeah. I mean, it's wild how much that really does play into the psyche. I mean, if you've got a serious case, and I think it also is, I mean, there's a lot of crimes that I think you just really have no sense of like what somebody, from like a average citizen, like what somebody would be looking at for a particular crime. And like when it's revealed, it might be like way less than you thought it was going to be, or it might be like significantly more time that they were facing. I mean, I think a lot of the drug related charges are in that thing of like, if this is this person's, first offense, or it's based on this dosage, like how in the heck could they be looking at 10 years in jail? Like that doesn't make any sense whatsoever, like regardless of what the circumstances are. I mean, it's just I do think it makes a big difference depending on the sentencing framework.
Yeah, and then I think especially with some of the trafficking laws are just ridiculous in this state, especially when you talk about opioids and those pills. When I think I just had a trafficking trial 4 weeks ago, and it was like 33 pills, and it's a trafficking amount. Yeah. So he's looking at 70 months. They double it because they want to do transport and by possession. So now, I mean, that almost helps me in a sense, like this kid just drug addict. I mean, I mean, he's using drugs.
Yeah.
He's got nothing on him that indicates he's selling it. Yeah. There's no scales. It's just a personal use. So I think that hurts in that regard for the state having that kind of increase. There really should be some flexibility in that. But.
Yeah, that's interesting. Well, I think one of the difficulties the first couple of times of like using the rule out theory on my end was that it's very, to me it was very uncomfortable. And also, like just jury trials in and of themselves are uncomfortable. Like you're trying not to look like an idiot in front of a bunch of other people in a very formal courtroom, like just trying to kind of like somewhat go unnoticed. And the rule out theory, the way that kind of David has it set up, really is very in your face. It's very much like, some big hype examples, and like really trying to get people to talk through these issues for kind of younger lawyers that are kind of early in the trial stage of things. What advice would you have in terms of like kind of getting comfortable being uncomfortable?
Yeah, I mean, it is one of those. I mean, when I started doing, when you start doing trial work, you're uncomfortable.
Yeah.
But I mean, uh, when I started doing David's, using some of his, incorporating and just kind of tailoring it's, everyone has to use what they're comfortable with, because again, it's authenticity with the jury too. But practice, the more you practice it, whether it's at home or in trial, certainly in trial, it helps you out. The more times you get in front of a jury, the more times, or you do focus groups, and I've done plenty of focus groups, especially during COVID. I just was doing them on Zoom, paying people to sit down and listen to me and my wife run cases and talk. So when those are helpful too, because you learn other things like my resting bitch face. So I consciously have to think in my head when I'm sitting there in trials, like just smile, normally I'm just, because we had them rate multiple times, rate me and my wife, and my wife's like, personal and all this other stuff, and I'm like really low on whether you want to have a beer with me or anything like that. I'm like, I gotta smile, show some teeth. It's so it's getting comfortable with that, getting comfortable with everything that I think David Ball's system is designed to be flexible with the person. I mean, some people just have more confidence than other people, and you got to make it work for yourself. There's no real one way. As you get more comfortable, though, you can start throwing in more outlandish examples and be a little bit more direct with it. But as you practice more, the judges know that about you, and they know, and they have more confidence that you know what you're doing. So they're going to give you more leniency too.
Yeah, that's such a huge point. I think for a lot of judges, just hearing something new, because you kind of know exactly as a judge how the prosecutor's voir dire is going to go. And you can go from one county, halfway across the state, and it's going to sound very similar. Like it's all kind of coming out of the same operator's manual, so to speak. So there's like an expectation of like, I bet you that most of them could tell what is the next question that is going to be asked by the prosecutor in this particular series of questions. But when it comes to the defense side of things, I think that there is, everything from, defense lawyers not asking many questions at all, to kind of like zeroing in on specific factual issues that might become come out during the course of trial. And so when you hear something that's kind of like a new way of presenting the case for the first time, I do think like the antennas go up. And so part of, I think, maybe the value of this system in terms of more attorneys potentially adopting it is that it becomes something where it's like, I've heard this before. It's really not that big of a, there's nothing somewhat new under the sun. This is the system of justice has not, collapsed because of the Tylenol example,
Yeah. I mean, the more people who use it, the better it is for all of us, because then it's like, all right, we've had, and I want everyone to get their fair trial.
Yes.
So,
yes.
Having that example out there and judges getting comfortable with that is important. I mean, judges they're always comfortable with whatever the state says, but our side is not so lucky.
We're not so boring.
Yeah, we come up with new ways.
Well, I love the thoughts about the rule out theory. I think it's huge to have a really kind of solid framework for presenting your case and what reasonable doubt is. And I think that, I remember in the CLE, maybe it was the same one. I don't remember
Yeah,
exactly where
maybe we were.
this was. I can't remember the location of it, but I remember him getting like so up in arms, and he's like, "You guys have the best standard. Like, I mean, that you should be winning so many more cases. You're just
Mhm.
not like hammering the reasonable doubt side of things." And I think that there's a bunch of different ways to attack or to communicate reasonable doubt. But the more that we can kind of look at some different theories and get better at that, the better off you're going to be in trial. So kind of with that, any kind of parting thoughts? I kind of tend to ask this question as kind of like the wrap up question.
Mhm.
What would be one piece of advice that you would give to a lawyer that's kind of 5 years or less into practice? What would be kind of the number one thing that you would want to communicate to them?
Well, I think preparation. I don't is probably the hardest when you're talking about trial work and just being. You can never be too prepared,
Mm-hmm.
and you also have to understand that you're going to get some of these things when you get kicked. Yeah, there's always things. There's always curveballs. You're never gonna be fully prepared for every kind of thing that happens in a trial, but you have to be able to try cases. So that's the only way you're going to learn. You can't just walk in with, you know, I don't want to drop any attorneys' names with a lot of experience, but with 100 jury trials under your belt, I mean, you're just not going to walk in that way. You've got to just got to keep practicing, and it is a practice. And that's what we always talk about. I think that's what makes this job so much fun is
Yes.
that there is no one way to do things, and that's what makes it exciting. And the things I'll throw in memes in my closings. I'll throw in, some sort of humorous thing if I can,
Yeah.
if it fits,
Got to
and
keep
just
the
to
attention.
get the jury's attention, and that be my personality. Don't be anyone you're not. Don't try and be Johnny Cochran if you aren't Johnny Cochran. That isn't your persona. It's be who you are, because that's what's going to win, is being authentic, and juries will pick up on that, and you just need practice. So
Yeah, I love that. That's awesome. Yeah, I think preparation is key, and I think you're gonna enjoy trial work a lot more if you're prepared than if you're not. So it's a
yeah, I mean,
much
once
better.
well, once you get the first few out of the way and prepare and over prepare,
Yeah,
you'll realize, okay, that might have been overkill, but
yeah.
you'd rather have it overkill than when you find that feeling on a Tuesday night when you go back home and you're researching 10
That's
topics.
awful.
That's the worst.
Well, sweet. Well, no, great advice, Justin. I really appreciate it. Yeah, I think that this is such a good way to frame your case as a criminal defense lawyer. And I really appreciate you coming on and sharing this with the audience.
Thank you for having me on.